We were just looking at this a few moments ago, some of these side panel excerpts during the commercial break. Judge Merchan raising his voice, quote, "I'm asking the questions. I'm going to be the one who decides whether your client is in contempt." Judge Merchan says he's been asking Trump's attorney questions. He isn't getting answers. Judge to Trump attorney, what I do see is I keep asking you over and over again for a specific answer. I'm not getting an answer. He sounds frustrated.
Yeah, to say it at the least, Jim, it's not going well for Todd Blanche right now. Trump's attorney, of course, who is defending his comments, or at least trying to, in this gag order hearing. But the judge is getting quite frustrated with Todd Blanche, and really where the point of tension began, as Todd Blanche was defending it, saying that Trump had not violated this gag order, even though the prosecutors just pointed to 10 instances where they said that he had. The judge was asking Todd Blanche, well, what specific post from Michael Cohen is Trump responding to? Because they were arguing that it was this barrage of legal attacks, and Todd Blanche clearly not providing that specific post, instead just kind of referring to them in the general sense. And the judge is getting quite frustrated with that.
Hello and welcome, guys. Adam is here. So what just happened? Trump's legal team is being publicly eviscerated in open court, with judges questioning their credibility, ethics, and competence, and forcing them to testify against clients. The once invincible dream team is collapsing in real time, as procedural games meet a judicial system that's no longer playing along. The documented record of Trump's legal team getting specifically and publicly rebuked by judges in formal court proceedings is absolutely devastating to examine. And this requires an honest timeline note up front, because the most vivid documented incidents are from recent years, not from the current week. These are real. They are documented by CBS News, The Wall Street Journal, The Telegraph, and multiple mainstream outlets. And they form a specific documented pattern of courts pushing back against Trump's legal team in ways that are worth examining as a pattern.
Yeah, I want to share one really quick note that we're seeing out of the court right now, and that is Judge Merchan saying to Donald Trump's attorneys, "You're losing all credibility. You are losing all credibility with the court. I have to tell you." This is in reference to this hearing that's underway right now about whether or not the former president has violated the gag order. There are 10 instances which the prosecution has brought up, which they are discussing. One of them involves a retweet that the former president did that was put out by a Fox News host about whether or not there were some people trying to get on the jury who were lying about what their intentions are to get on the jury. And the former president, he retweeted that. And the attorney for Donald Trump said he should not be held in contempt for doing those kinds of things. And then the judge asked him, well, specifically, who was doing these tweets? And the Trump attorney says, well, there's a group of people who are doing things.
Here's what the documented record shows. During a bruising contempt hearing in Trump's New York hush money criminal case, Judge Juan Merchan told Trump attorney Todd Blanche directly, "You are losing all credibility with the court." That is a judge in a formal court proceeding using those specific words to describe his assessment of a Trump attorney's courtroom arguments. Merchan also criticized Trump for manipulating what was said in court and putting it in quotes in a Truth Social post, pressing Blanche to explain why that was acceptable while the gag order was in effect. The Telegraph described the exchange as a bruising contempt hearing. Salon and Yahoo News documented the judge shutting down the Trump lawyer at a brutal contempt hearing. In another incident, Trump attorney Evan Corcoran was compelled to testify for more than 3 hours before a federal grand jury after a judge ruled that his attorney-client privilege claims were invalid under the crime fraud exception in the classified documents investigation.
There's some brand new reporting to tell you about that we can add to the pile that has been building over recent weeks of developments and new public-facing evidence, signs, if you will, all suggesting that obstruction of justice charges could be coming in the DOJ investigation into the ex-president's handling of classified documents. The Washington Post reports that top Trump lawyer Evan Corcoran has, quote, recused himself from representing the ex-president, specifically in the special counsel's documents case. More from that reporting, quote, grand jury proceedings are secret, so it's not immediately clear how helpful Corcoran's testimony might be to Jack Smith and his team. But legal ethics rules, including those in Maryland and Washington, D.C., generally bar lawyers from acting as advocates at trial when they are likely to be essential witnesses.
That ruling, the crime fraud exception being applied to override a Trump attorney's privilege claim, is one of the most significant legal setbacks for Trump's defensive legal strategy in the documented record. And the Wall Street Journal reported that a federal judge rejected Trump's attorney-client privilege claims in the Mar-a-Lago documents case, ordering further testimony from Trump's lawyer and marking what the Journal characterized as a major courtroom setback for Trump's legal shield. Those three documented judicial actions, Merchan's "you are losing all credibility" rebuke, the Corcoran crime fraud compelled testimony, and the privilege claim rejections in the Mar-a-Lago inquiry, are the specific documented legal record this script examines as a pattern.
President losing this executive privilege claim. Talk to me about what you've been reading, what you know.
Yeah, I don't think there's any doubt, Don, that this is a significant victory for the January 6th Select Committee. They have interest in hundreds of documents from the Trump administration that occurred in and around the January 6th attack. That includes call logs, visitor logs. It includes some of the documents that were created during the Trump administration's time in office, and also even handwritten notes that the president himself had authored during that time frame. And in her ruling, the judge made it very clear that when weighing this kind of balance between executive privilege and the public interest, that the public interest was much more important. She wrote, quote, "The court holds that the public interest lies in permitting, not enjoining, the combined will of the legislative and executive branches to study the events that led to and occurred on January 6th and to consider legislation to prevent such events from ever occurring again."
Before we go any further, the final warning and lawyer crumbles. Framing requires the same honest handling I've applied throughout this series. The Merchan hearing is a documented event from the criminal trial period. The Corcoran grand jury testimony is a documented event from the federal documents investigation period. The Wall Street Journal privilege rejection is from the same federal documents investigation period. These are real documented events with real documented consequences, but they are not breaking news. They are the documented legal history that established the pattern. This script is examining a pattern that is relevant to the current political moment, because Blanche is now the acting Attorney General of the United States. And Todd Blanche's credibility questions have taken on a different institutional significance. That is why we built Pump Politics. Real stories, real context, no corporate spin. Join our free newsletter and get the news straight to your inbox every single day. Click the link in the description, and if you want to support what we are building, join the community. All right, back to it. Let me explain why the pattern documented in those three judicial actions is specifically significant in the current second-term context, because the significance has changed since the events occurred. Todd Blanche, whose credibility Judge Merchan publicly questioned, is now the acting Attorney General of the United States. The same person whose courtroom arguments drew "you are losing all credibility" from a sitting judge is now the official who is managing the DOJ's handling of the Epstein files, facing a congressional subpoena from the House committee, and whose conflict of interest as Trump's former personal defense lawyer is the specific concern that legal experts have documented. The judicial rebuke of Blanche's courtroom conduct is the documented professional history of the person now wielding the Attorney General's institutional authority. And Evan Corcoran, whose attorney-client privilege was overwritten by the crime fraud exception, is a documented example of how courts have treated the specific privilege claims Trump's legal team has used as a defensive shield across multiple proceedings. All right, so let us go through the specific documented incidents carefully, because the Merchan-Blanche exchange, the Corcoran crime fraud compelled testimony, the privilege claim rejections, and the pattern they formed together each deserve their own analysis. Let us start with the Merchan-Blanche exchange, because this is the most specifically documented of the judicial rebukes and the one with the most specific and memorable language in official court record. Judge Merchan's "you are losing all credibility with the court" statement is the kind of specific judicial language that is specifically notable in its directness. Judges routinely express skepticism about arguments before them. That is a normal part of adversarial legal proceedings. What is less routine is a judge specifically addressing the credibility of the attorney presenting the arguments rather than just rejecting the arguments themselves. Merchan's "you are losing all credibility" framing is a judicial assessment of the attorney's professional standing with the court, not just a ruling against the argument being made. That distinction is significant because professional credibility with the court is the specific asset that makes an attorney effective in advocating for their client. A judge who publicly tells an attorney he is losing all credibility is communicating that the attorney's advocacy is becoming counterproductive rather than helpful to the client's position. That communication in a formal court proceeding from a sitting judge about the president's lead criminal defense attorney is the specific documented judicial assessment that makes the Merchant-Blanche exchange significant beyond the immediate gag order question. The specific trigger for Merchant's credibility assessment was Trump's Truth Social post about witnesses and the pattern of those posts connecting to what Merchant described as manipulating what was said in court and putting it in quotes. The gag order in the hush money trial was specifically designed to protect witnesses and court staff from harassment and intimidation. The specific conduct Merchant was addressing was Trump misquoting courtroom testimony in Truth Social posts, creating public characterizations of what witnesses said that Merchant found to misrepresent the actual courtroom record. Blanche was in the position of defending those posts against a gag order violation finding, and his arguments were producing the "you are losing all credibility" assessment from the judge. The specific challenge for Blanche in that hearing was that the posts were public. The court record was public, and any comparison of the two was available to the judge independently of what Blanche argued. Defending posts that misrepresented the courtroom record to a judge who had direct access to the courtroom record was the specific advocacy challenge that Merchant's credibility assessment reflects. The Evan Corcoran crime-fraud exception ruling is the most legally significant of the documented judicial actions because the crime-fraud exception to attorney-client privilege is one of the most powerful legal tools available for piercing the lawyer-client confidentiality that normally shields legal communications from disclosure. Attorney-client privilege is a foundational principle of American legal representation. Clients are supposed to be able to communicate candidly with their lawyers without fear that those communications will be disclosed to prosecutors or courts. The crime-fraud exception overrides that privilege when there's probable cause to believe that the attorney's services were sought or used in furtherance of a crime or fraud. A judge applying the crime-fraud exception to order a Trump attorney to testify before a grand jury is a judge finding probable cause that the attorney's services may have been used in furtherance of the alleged criminal conduct being investigated. CBS News documented that Corcoran testified for more than 3 hours before the federal grand jury. That 3-hour testimony compelled over Corcoran's privilege objection is the documented consequence of the crime-fraud exception ruling, and the Wall Street Journal's reporting on privilege claim rejections in the broader Mar-a-Lago inquiry extends that same pattern. Courts finding that the specific privilege claims Trump's legal team was relying on to shield attorney testimony were either not valid under the crime-fraud exception or were otherwise not sufficient to block the compelled testimony. The connection between the privilege claim rejections and the broader legal strategy is the thread that makes the documented judicial pattern most analytically significant. Trump's legal strategy across multiple simultaneous proceedings has relied heavily on specific defensive tools, gag order challenges, attorney-client privilege claims, executive privilege assertions, procedural delays, as the primary mechanisms for limiting the scope of judicial scrutiny of his conduct. Each of those defensive tools has faced specific judicial challenges in the documented record. Gag order challenges produced the fines and the credibility warnings. Attorney-client privilege claims produced the Corcoran crime-fraud exception compelled testimony, and the Wall Street Journal documented Mar-a-Lago privilege rejections. Executive privilege claims produced the records litigation and the ballot access cases. The pattern across all of those defensive tools is courts finding them insufficient to shield specific information from judicial scrutiny in specific contexts, creating a documented record of the defensive legal strategy encountering specific and documented judicial limits. The broader pattern of Trump lawyers being compelled to testify or having their arguments publicly rebuked is the connection point that accurately identifies the larger narrative about his legal shield crumbling. A legal shield's effectiveness depends on its capacity to prevent compelled disclosure of information the client wants to keep confidential, and on the attorney's ability to make effective credibility-maintaining arguments to the courts making the disclosure decisions. The Corcoran compelled testimony is the documented failure of the privilege shield in the classified documents context. The Merchan credibility rebuke is the documented failure of the credibility dimension of effective advocacy in the hush money gag order context, and the Wall Street Journal privilege rejections in the Mar-a-Lago inquiry are the documented pattern of privilege claims being specifically evaluated and specifically rejected in that investigation's context. Together, the documented judicial record shows a specific pattern of the legal tools being used to protect Trump's position, encountering judicial limits that the "you are losing all credibility" framing is capturing in its most vivid available form. The Todd Blanche dimension connects the documented courtroom record to the current second-term institutional picture in the most politically significant way. Blanche, whose courtroom credibility was specifically questioned by Merchan, was subsequently chosen by Trump as his acting attorney general in the second term. That specific appointment is the institutional translation of the Trump lawyer pattern into the current governance situation. The person whose arguments drew "you are losing all credibility" from a judge in a criminal contempt hearing is now the acting head of the Department of Justice, the same department that is managing the Epstein files release, facing the congressional subpoena, and whose conflict of interest as Trump's former personal defense lawyer is the subject of legal analysis. The documented judicial assessment of Blanche's courtroom credibility is the professional history of the personnel wielding the department's institutional authority. And it is the specific context that makes the documented lawyers getting rebuked pattern relevant to the current second-term accountability picture. Okay. So let me be really clear about what the documented judicial rebuke pattern means and what it specifically establishes about Trump's legal strategy and its limits. The first thing to understand is the specific significance of the "you are losing all credibility" judicial assessment and why it is distinct from a standard adverse ruling. Courts rule against arguments routinely. It is the normal functioning of the adversarial legal system. Both sides make arguments. The judge evaluates them, and one side wins. Losing an argument is not a credibility crisis. What Merchan expressed was not just a rejection of a specific argument. It was the judicial assessment that the argument being made was undermining the attorney's standing with the court more broadly. That broader credibility assessment, expressed specifically about Trump's lead attorney in the context of a gag order hearing where the attorney was defending posts that Merchan found to misrepresent the courtroom record, is the documented judicial evaluation that the lawyer CRUMBLES framing is capturing. A lawyer who is losing all credibility with the court is a lawyer whose future arguments will be received with less charitable judicial attention than they might otherwise receive because the credibility assessment colors the court's evaluation of subsequent advocacy. The second layer we're sitting with is the crime-fraud exception, and what its application to Corcoran's privilege claims tells us about how courts assess the classified documents investigation. The crime-fraud exception requires a judge to find before ordering a lawyer to testify that there is probable cause to believe that the legal services were used in furtherance of crime or fraud. That is a specific judicial finding, not just a procedural ruling. A judge ordering Corcoran to testify under the crime-fraud exception is a judge who found probable cause that the attorney's communications may have been connected to the criminal conduct being investigated. That finding, documented through CBS News's reporting on the grand jury testimony, is the most significant judicial assessment in the documented record of how courts view the classified documents investigation in its active phase. The Trump team's response to the Corcoran compelled testimony and the privilege rejections was to characterize them as legal persecution, the same rigged system framing we've seen across multiple investigations. But the documented judicial findings underlying those rulings, crime-fraud exception applied, privilege claims rejected, are the specific judicial assessments of what was being claimed and found insufficient. The third layer is the Blanche now as AG dimension, and why the documented judicial assessment of his courtroom credibility is specifically significant for evaluating his current institutional role. We've documented how Blanche's management of the Epstein file releases with days past deadline non-compliance, and his conflict of interest as Trump's former personal defense lawyer are the specific accountability concerns his AG nomination is raising. The documented merchant credibility assessment is the professional history that precedes those accountability questions. A congressional subpoena to the acting AG is more consequential and more politically significant when the acting AG's courtroom conduct as Trump's personal lawyer was specifically assessed as credibility losing by a sitting judge. The judicial record and the institutional accountability questions are different dimensions of the same documented picture of how Blanche's professional conduct has been assessed by multiple accountability actors across different settings. Now, to give the complete and fair picture, Trump and his supporters have arguments about the documented judicial rebukes and compelled testimonies that deserve acknowledgement. They would argue that Merchan's "you are losing all credibility" assessment reflects a judge whose hostility to the Trump defense team was itself documented, that the hush money case was brought by a Democratic prosecutor in a Democratic city before a judge who Trump publicly characterized as biased, and that the credibility assessment reflects that judicial hostility rather than a neutral assessment of Blanche's legal arguments. They would argue that the crime-fraud exception ruling on Corcoran reflects an overly aggressive use of that exception by a judge who was predisposed toward the prosecution, and that the application of crime-fraud to a Trump attorney's communications reflects the same selective DOJ targeting that Trump and his allies have consistently documented across multiple investigations. And they will argue that privilege claim rejections in adversarial proceedings are the expected outcome when prosecutors push for maximum information disclosure, and that specific privilege rulings in active investigations do not establish the broader lawyer CRUMBLES characterization that the research is using. These are real arguments. Judicial bias claims in Trump cases have been made and have some documented grounding in Trump's documented public statements about specific judges. The crime-fraud exceptions application is always contestable. Privilege rulings in adversarial proceedings are the expected outcome of prosecutors pushing hard. These deserve acknowledgement. But here's what those arguments run into when you apply them to the documented record. The "you are losing all credibility" assessment was specifically triggered by what Merchan found to be misrepresentation of courtroom statements in public posts. A factual determination about the accuracy of Trump's Truth Social post relative to the court record rather than a purely ideological judicial reaction. The crime-fraud exception application to Corcoran required a judicial finding of probable cause, a specific evidentiary standard rather than simply a judge's political preference. And the Wall Street Journal privilege rejections in the Mar-a-Lago inquiry were documented across multiple federal court proceedings, whose judges were operating under different judicial assignments, making the simultaneous hostility explanation harder to sustain across multiple separate courts. The documented pattern across multiple courts, multiple attorneys, multiple proceedings of Trump's specific legal defensive tools, encountering specific and documented judicial limits, is a broader pattern than the individual judicial hostility explanation can account for. So here's the bottom line on all of this. A judge told Trump attorney Todd Blanche, "You are losing all credibility with the court," during a contempt hearing over gag order violations in the hush money case. Also finding that Trump manipulated courtroom quotes in Truth Social posts. Another attorney was compelled to testify for more than 3 hours before a federal grand jury after a judge applied the crime-fraud exception to override his attorney-client privilege claims. And a federal judge rejected Trump's attorney-client privilege claims in the Mar-a-Lago inquiry, ordering further attorney testimony. The documented pattern across those 3 judicial actions: you are losing all credibility, crime-fraud exception applied, privilege claims rejected, is the lawyer gets rebuked record that the final warning framing is based on. And the current second-term significance of that documented pattern is the institutional context of Todd Blanche, whose courtroom credibility was specifically questioned, now serving as the acting attorney general, managing the Epstein files, facing a congressional subpoena, and raising the conflict of interest concerns. But hey, if you think the documented judicial rebukes of Trump's legal team represent the final chapter of the Trump lawyers getting slapped down pattern, think again. The congressional subpoena to Blanche, the ongoing Epstein file non-compliance documentation, the IRS settlement challenge in the courts, and the continuing legal proceedings across multiple jurisdictions are all producing new entries in the same documented record. The legal shield that the "you are losing all credibility" assessment, the crime-fraud compelled testimony, and the privilege rejections were already starting to penetrate is the same shield whose holes are being documented in the second-term accountability proceedings. You are going to want to be here as the second-term entries accumulate. The idea that Trump sells himself as someone who never loses in court while courts are actually finding documented limits on his legal strategy is worth examining specifically because it connects the documented legal record to the broader political narrative. Trump's political brand has consistently incorporated a legal invincibility element, the idea that no prosecution will succeed, no judge will ultimately hold him accountable, and that every legal setback is temporary while every win is permanent. That brand element has been politically effective in part because the record of any individual proceeding is complex enough that both wins and losses can be characterized as the dominant pattern depending on which results you emphasize. The documented "you are losing all credibility" assessment and the crime-fraud exception compelled testimony are the specific moments where the complexity of the legal record gives way to concrete documented judicial statements that are harder to spin in either direction. A judge telling your lead attorney he is losing all credibility is a specific and documented judicial assessment that cannot be characterized as a win. A court applying the crime-fraud exception to override your attorney's privilege claims is a specific and documented judicial finding of probable cause that the privilege was being used in connection with potentially criminal conduct, not a neutral procedural ruling. Those specific, documented judicial assessments are the entries in the legal record that the legal invincibility framing is most directly challenged by. They are not convictions. They are not final adverse judgments. But they are specific documented moments where the legal invincibility brand encountered documented institutional resistance that is in the public record for journalists, historians, and accountability-minded citizens to evaluate. The pattern of lawsuits being dismissed or lost is the civil litigation equivalent of the same documented pattern. First Amendment protections defeating defamation claims, executive orders being blocked by courts, the H-1B fee permanently enjoined, the tariff ruling, the IRS settlement challenged. Each of those documented judicial outcomes adds to the accumulated legal record that is being set against the never loses brand. The legal invincibility depends on the public record being too complex for a clear pattern to emerge. The accumulated documented record across multiple types of proceedings, multiple courts, multiple specific legal tools being found insufficient, is the pattern that is most accurately pointing at showing documented limits. The limits are not total. The immunity ruling is real. The ballot access ruling is real. The legal victories are documented alongside the defeats. But the pattern of specific documented limits on specific defensive legal tools is also documented, and it is the specific accountability record that responsible coverage assembles alongside the documented victories. The Todd Blanche institutional appointment dimension deserves its own brief analysis because it connects the documented courtroom record to the current second-term accountability questions in the most direct way available. Blanche was confirmed as acting attorney general after serving as Trump's lead personal defense attorney. The attorney whose courtroom conduct produced Merchan's "you are losing all credibility" assessment. The appointment of a president's personal defense attorney as the head of the Justice Department is itself a documented institutional accountability concern regardless of the specific courtroom conduct. the conflicts of interest that the appointment creates, the acting AG managing investigations that may implicate his former client's conduct, managing Epstein file releases that could implicate his former client, managing DOJ processes that could affect his former client's legal exposure, are the specific institutional concerns that legal ethics experts and oversight members have been raising. The conflict of interest analysis and the non-compliance documentation are the specific institutional accountability responses to the Blanche appointment, and the "you are losing all credibility" judicial assessment is the professional conduct history of the person those accountability responses are now targeting as the acting Attorney General. That documented professional history, courtroom conduct that a judge specifically characterized as credibility losing, is the accountability context that makes the Blanche story more than a standard conflict of interest concern. It is a specific documented judicial assessment of how the person now wielding the department's institutional authority has previously been assessed by an institutional actor with first-hand observation of his professional conduct. The congressional subpoena is attempting to compel the same Blanche, whose courtroom credibility was specifically questioned, to provide testimony about his management of the Epstein files as acting AG. That specific accountability architecture, documented judicial assessment followed by second-term congressional subpoena, is the institutional record this script is most directly pointing to. Make sure you're subscribed because this is going to keep developing and changing. This story is far from over. Hit that subscribe button. I'll see you next time.